Hello everyone. So I will be beginning with Unit 7 Legal Profession in India. So the history of legal profession I have already covered from the older version of this book, and that's already uploaded. So I will be coming up to the Advocates Act 1961. The objective was to amend, that is to change, consolidate, that is to combine all in one place, the law relating to legal practitioners and provide for constitution, that is the establishment of bar council and all India bar. The Advocates Act was passed. The main provisions are one category of practitioners, that is advocate. That means those six grades that we did or we came across in the last video, that all was done away with, and all they were all included under the one category, one umbrella, that is of advocate. So all the old categories were abolished and consolidated into a single category called advocates, who enjoy the right to practice in courts throughout India. So that enrollment in particular court or particular high court, and then the restrictions for getting enrolled in the other high court in other place, all that was done away with. It was a central act after independence, so no such restraints were to be put. There was equality established as per the Constitution of India as well. So keeping all that principles in mind, now people had the right uniformly to enjoy practicing, to enjoy the right of practicing law in courts in the whole of India. The Act recognizes only one class of practitioners, that is advocates. Advocate have been classified, that means we have category of senior advocates, and whosoever are left, they are the other advocates. So we do not say senior advocate and junior advocate, we say senior and other. Okay. An advocate on state roles, it's entitled to practice as of right, means he has a right to practice before any tribunal authority of India or any court including the Supreme Court. That means who is enrolled in a particular state, there is a bar council of state, there is a bar council at national level also. So the lawyers who are enrolled, who have their names enlisted in the list of advocates in that particular state, they can also fight the case or practice law even in the Supreme Court. So there is no bar as to in which particular place you are enrolled, so you have to practice there only. ऐसा कोई बार अब नहीं है. बार मीन्स ऑब्स्टिकल या रिस्ट्रेन. ठीक है. Advocates, in order to be eligible for enrollment, he must be a citizen of India. So here the nationality comes into picture, that you should be an Indian. Even in all the government jobs that are mostly prescribed, the basic qualification is the Indian citizen. At least 21 years of age and having LLB degree from an Indian university. So LLB, that is the graduation, should be from the Indian university, which is granted the due recognition by the government. Right. The Bar Council approves the minimum standards for all the educational institutions who are imparting legal education. So from such एजुकेशनल इंस्टीट्यूशन जिसको रिकग्निशन बार काउंसिल ऑफ इंडिया ने दिया है, वहाँ से, उसमें से किसी भी एक यूनिवर्सिटी या इंस्टीट्यूशन से आपको LLB डिग्री होना मैंडेटरी है. एंड दिस इज़ टू मेक श्योर दैट द बेसिक नॉलेज ऑफ लॉस ऑफ द लैंड, दैट इज़ इंडिया, वो उस पर्सन के पास है. दैट can be the part of legal training or legal course that the concerned person has. Any advocate enrolled in state roles is entitled to practice in all courts of India, including Supreme Court. There is an additional requirement of all India bar examination since 2010, which advocates must clear in order to be able to start practice. Now, for a sweeper, job of sweeper in Allahabad High Court, the recent vacancy that I have observed last year, there was examination, there were qualifications that you should be class 6th passed or class 10th passed. So for every smaller to lower post or greater to greater post, there is an examination, pen and paper test, which is conducted nowadays, right? So To start practice also there is a test which is AIBE, All India Bar Examination, and this was into picture since 2010 till today. A foreign national may be enrolled on a reciprocal basis with country of his citizenship, and his foreign degree may be recognized by council for the purpose. Reciprocal means that if I am giving you certain thing, that you also should give me the same thing back, or something or the other back. That means over here it means that if India is recognizing a person of a particular foreign country and providing him the right to practice in the court of India, right, then that country also should provide the degree or the certificate for practicing to an Indian national. ठीक है, अगर मैं आपके कंट्री के बंदे को अलाउ कर रही हूँ अपनी कंट्री में प्रैक्टिस करने के लिए, तो आपको भी मेरी कंट्री के किसी लॉयर को अलाउ करना होगा कि वो आपकी कंट्री में प्रैक्टिस करे. दैट इज़ द रेसिप्रोकल बेसिस. ओके, द कंट्री ऑफ हिज सिटीजनशिप मीन्स जहाँ की सिटीजनशिप उस पर्सन के पास है. नाउ नेशनैलिटी एंड सिटीजनशिप आर टू डिफरेंट थिंग्स, एंड बहुत माइन्यूट और ओवरलैपिंग डिफरेंस है इनके बीच का. दैट नेशनैलिटी मीन्स वेयर द पर्सन इज बॉर्न, ओके, and citizenship means where he is living from a longer duration of time and he has the intention to reside there only permanently. He has no intention of changing his citizenship. Okay, so their intention also marries. But nationality में जहाँ आप born हुए हो जिस country में, उसका nationality आपको automatically मिल जाएगा, and you cannot have the option of या intention of changing it, although you can withdraw or you can revoke the nationality. ठीक है. And suppose there are many people who are Indians as per the nationality and citizenship also, but there may be some people like the example of Akshay Kumar. ठीक है, he is not an Indian national but he has obtained the citizenship of India. Fine. So in the absence of such reciprocity means if there is no such reciprocity, then foreign nationals cannot practice law in India. So that is the basic condition to allow foreign national practicing in India, that in their country Indians are also allowed to practice. And this is on the basis of the reciprocal agreements which India may have entered into with different countries of the world. ठीक है. सो ऐसा नहीं है कि सब कंट्री के साथ ये अग्रीमेंट्स आर इन प्लेस, बट देर मे बी सम कंट्रीज़ जिसके साथ इंडिया ने ऐसा अग्रीमेंट कर रखा है. सिर्फ उन्हीं कंट्री में टू एंड फ्रो ये चीज़ें अलाउ करी जाएंगी. Senior advocate and advocate on record. The Advocates Act make a provision for two kind of advocates. However, the Supreme Court has in exercise of its rule-making power made a provision for advocate on record. The distinction amongst them is as follows. Now this is an act that was made by legislature, but the Supreme Court, since it also has the power to make some rules for the administration, it has made a provision for advocates on record. And what is the distinction? Senior advocates are designated as such by Supreme Court or by any High Court. The court can designate any advocate with his consent as senior advocate if, in its opinion, by virtue of his ability and standing at the bar, that is the bar council, or special knowledge or experience in law, the said advocate is deserving of such distinction. Section 16 of Advocates Act. So he may have the knowledge, experience or the practice since so many longer duration of years in the court, and the ability also that he is capable or he is deserving to be at that position. He is a man of good character. He has fought these many cases and he was successful in majority of them or all of them, right? He has worked for the welfare or the best interest of his or her client, right? So all that will be considered, and the concerned person's consent will also be taken that it is my recommendation that you will be designated as the senior advocate. Do you agree, or can I designate you with this position? Because of course, if you are designating somebody as a higher rank, then some duties or responsibilities also come into picture. As such formal duties ना हो, but at least एक मॉरल रिस्पॉन्सिबिलिटी तो होती है कि उस पोजीशन जो आपको दी गई है आप उसको मेंटेन करो, उसको कैरी फॉरवर्ड कर पाओ, एंड टू सेट एन एग्जाम्पल टू अदर्स, to your juniors, right? So all that has to be seen. Senior advocate is not entitled to appear without an advocate on record in Supreme Court or without a junior in any other court or tribunal in India. That means he cannot appear without an advocate on record of Supreme Court or without a junior. So if he is appearing for fighting a case of the client, he has to appear with advocate on record. If he is so appearing in the Supreme Court, and if he is appearing in any other court or tribunal in India, then he has to appear with a junior. ठीक. He is not entitled to file wakalatnama in any court or tribunal or accept instructions to draft pleading or affidavits, advice on evidence, or to do any drafting work of an analogous kind in any court or tribunal. Analogous means सिमिलर काइंड, ठीक है? जैसे हम कहते हैं कि एनालॉगी ड्रॉ करो, कंपैरिजन ड्रॉ करो. सो ही इज़ नॉट एंटाइटल्ड टू फाइल वकालतनामा. वी डिड इन द लास्ट क्लास, इन द लास्ट वीडियो. सो वकालतनामा वो फाइल नहीं कर सकते किसी भी कोर्ट या ट्रिब्यूनल में. साथ ही साथ ही कैन नॉट एक्सेप्ट instructions on how to draft pleading or affidavits, or to get advice on evidence, or to do any such drafting work. वकालतनामा भी ड्राफ्टिंग जो होती है, प्लीडिंग जिसका मैंने बोला था लास्ट वीडियो में, उसके साथ ही वकालतनामा बनाया जाता है. ही इज़ नॉट अलाउड टू फाइल एनी प्लीडिंग और ड्राफ्ट एनी सच in any court or tribunal. Also, he is not allowed to file the वकालतनामा. Designated senior advocate wears a gown with a flap at the back. So आपने देखा होगा कुछ advocates जो होते हैं, they also wear gown as the judges wear, right? So that is the aura, and these are the restrictions which come along with the post. So that's why the consent of the concerned person is important. Okay. Advocates on record. Only these advocates are entitled to file any matter or document before Supreme Court. On record means their name or whatever their basic credentials are, they are mentioned in the documents in the public record of the Supreme Court. So only those advocates who are enrolled as such, they have the right to file any matter or document before the Supreme Court. Any matter means matter क्या होगा, उनके client का ही तो matter होगा, उससे रिलेटेड वो जो भी डॉक्यूमेंट, एफिडेविट या प्लीडिंग ड्राफ्ट करके फाइल कर रहे हैं, ठीक है? तो कौन फाइल करेगा? एडवोकेट्स ऑन रिकॉर्ड कैन ओनली डू एज फार एज द सुप्रीम कोर्ट इज कंसर्न्ड. They can also file an appearance or act for a party in Supreme Court. That means they can apply for a particular party for permission so that a particular party may appear in the Supreme Court. No other high court has a similar provision. So this is not applicable for the high courts in India, but only for Supreme Court. If one wants to practice as an AOR in Supreme Court, he or she needs to practice for 4 years as an advocate, and then must intimate to the Supreme Court that he has started taking training with a senior advocate on record, because he intends to become an advocate on record. So advocate on record senior कौन सा होगा? जो उनसे ज़्यादा साल से काम कर रहा है, he will be the senior one. So he has to first do practice for 4 years as an advocate, and then जब वो ट्रेनिंग स्टार्ट कर दे किसी सीनियर के अंडर, तो intimate, that is, he has to inform to the Supreme Court that I have started such and such training with such and such senior advocate on record. Because, and also he has to make clear of his intention to become an AOR in future. After completion of 1 year's training, he has to appear for an examination conducted by Supreme Court itself. So 1 year training has to be done, after which an examination would be conducted. After an advocate passes this examination, he must have a registered office within a radius of 10 miles from Supreme Court building and a registered clerk. So once the person becomes AOR, तो उसका एक office होना चाहिए that we call chamber, and that should also be registered, and the location should be the radius of 10 miles from the building of Supreme Court. That means if this is the Supreme Court, तो इसके 10 miles, यहाँ से 10 miles रेडियस यू नो ऑफ अ सर्कल, हर जगह से इक्वल डिस्टेंस होता है, तो उसके 10 miles तक इट शुड बी द ऑफिस एंड द क्लर्क ऑल्सो. एक क्लर्क भी उसको रखना है जो कि सारा उसका टाइपिंग और डॉक्यूमेंटेशन वर्क करेगा. Only an AOR can file wakalatnama in Supreme Court on behalf of a client. Any correspondence by Supreme Court is sent to the AOR. So AOR can only file the wakalatnama. He can only appear for filing any document or matter in the court like we did. State Bar Councils. The Act has created a State Bar Council in each state with Advocate General of the state as an ex officio member and 15 to 25 members elected for a period of 5 years. Now, since there is a council, so it would have some members or officers under it. So the constitution of the council goes like: the Advocate General of the state, who is the ex officio or the head you can say, and 15 to 25 members की range होती है who have the term of 5 years. Now, state has Advocate General. Similarly, the central government also has such similar nomenclature post who fights the case for the central government or union government. You may have seen in some cases it is written versus Union of India, or the crimes that I told you, crime is against the whole society. So the government fights the case on behalf of the primary victim of the matter, right? तो ये गवर्नमेंट एज सच तो आकर नहीं लड़ेगी, उनका कोई लॉयर होगा, राइट? तो ये जो लॉयर है उनका क्या नाम है, यू हैव टू फाइंड इट आउट, दैट इज़ योर होमवर्क. सिमिलरली इन द मैटर्स ऑफ such state government, if state government is in a dispute with other state government or with the central government, or there is a crime committed in a particular state, तो उस मैटर को लड़ने के लिए स्टेट गवर्नमेंट ने अपना एक लॉयर अपॉइंट किया है. सो दैट इज़ हु, द एडवोकेट जनरल. फाइन. 2 members nominated by BCI from amongst advocates on electoral roll to discharge the functions of State Bar Council. So out of these, 2 members are nominated by the BCI. Application for enrollment is made to State Bar Council. Every State Bar Council shall prepare and maintain a roll of advocates in which shall be entered the names and addresses of all who are admitted to be advocates on roll of State Bar Council under this Act or on after the appointed day. So the list of all such people have to be maintained with the basic credentials including their name and addresses. Okay. हर जगह स्टूडेंट्स भी जो एडमिट किए जाते हैं किसी स्कूल में, तो उनका नाम, फ़ोन नंबर, पेरेंट्स नेम एंड ऑल सच डिटेल्स आर एंटर्ड. सो सिमिलरली इट इज़ अ बार काउंसिल, वहाँ पर भी एक लिस्ट मेंटेन करना और एंटर करना ज़रूरी है. फंक्शंस: to admit persons as advocate on its roll, to prepare and maintain such roll, to entertain and determine cases of misconduct against advocates on its roll. So if somebody has done something or spoken some abusive slangs, or he has beaten up or thrashed an advocate on roll, then it is matter of misconduct against such person. तो उसको कैसे एंटरटेन करके इन्वेस्टिगेट करके डिसीजन देगा. और सिंस लाइक it is said no that in a particular school till the time students are in the school premises or they wear the uniform of their school, it is the responsibility of the school to protect them, to protect the safeguards or to protect the bodily integrity. राइट अगर स्कूल टाइम में बच्चे को कुछ भी होता है तो पेरेंट आकर टीचर से पूछेगा कि इसको ये चोट कैसे लगी. Isn't it a very basic example? तो अगर ये एडवोकेट्स एनरोल्ड हैं अंडर अ पर्टिकुलर स्टेट बार काउंसिल, ठीक है, और if some misconduct is committed upon them or some assault is committed against them, तो यहाँ पर why they have to determine or deal with such cases, because it is the responsibility of that bar council to protect the interests or integrity of those advocates who are enrolled under it. That is to safeguard the rights, privileges and interest. To promote the growth of bar association for purpose of effective implementation of welfare schemes, right? So whatever the schemes are made or policies are made by the concerned state or central government, to implement them effectively and to see the development of their implementation as well, it is important. And there may also be schemes which are made by the government for the welfare or the betterment of the lawyers, right? The new legislations which would have come, तो उनको implement करना सही से, that is also important. Promote and support law reform, because their main function is to work with law, to practice law. So whatever changes are coming as per the time, law is a very dynamic subject, as we say, right? It changes with society and time. So whatever changes are coming, to accommodate to it and to promote it also, कि हाँ, now this law is obsolete, now this law is not fitting as per the prevalent conditions today, it needs to be changed, right? ऐसे suggestion देना, उसको promote करना. And if there is one such reform which is made, if a law has been modified, like the recent example of the criminal laws which are changed, right? तो ऐसे law reform को support करना. To conduct seminars, organize talks on legal topics by eminent jurists and publish journals and paper of legal interest. So their main concern is with the legal subject. So the seminars or talks means podcast या वो सब जो आप सुनते हो on legal topics by jurists or judges, and they may also publish some research papers or journals, or you may see some PDFs which are uploaded on internet, right? So that is what a general. Paper here means research paper. They may have done some research on a particular topic and then that has been published. Published means it has been put on the public record so that anybody can read and learn from it. To organize legal aid to poor in the prescribed manner, free legal aid, because there are many people in the country who are not even able to afford or arrange for the 2 square meals a day. और अगर उनके साथ किसी ने कुछ गलत काम कर दिया या कुछ भी डिस्प्यूट हो गया तो उनके पास खाने तक के तो पैसे नहीं है, वो अपने लिए केस कैसे लड़ेंगे? लॉयर की फ़ीस, डॉक्यूमेंटेशन फ़ीस, कोर्ट फ़ीस, ट्रैवल एक्सपेंसेस, या अगर किसी और दूर जाकर कोर्ट में केस फाइल हुआ है तो वहाँ पर रहने के लिए कोई जगह भी रेंट करनी पड़ेगी, होटल में भी अगर रहना पड़े तो हाउ दैट ऑल दे वुड बी एबल टू अफोर्ड, राइट? सो इसलिए जो लीगल एड दी जाती है, एड मीन्स हेल्प टू द पुअर, उसके लिए अरेंज करना, उसको इफ़ेक्टिवली प्रमोट करते हुए इम्प्लीमेंट करना कि हाँ, दिस इज़ द पर्सन हु इज़ नॉट एबल टू have the money to accommodate such expenses, so I am providing, or the court is providing with the legal aid. Manage and invest the funds. So whatever funds, or since it is a government body, so कुछ funds government allot कर रही होगी, उसको कैसे use करना है, that all has to be seen. It also has to manage the records. हर गवर्नमेंट बॉडी में जितना भी फंड आ रहा है वो कहाँ कितना खर्च हुआ उसके भी रिसिप्ट्स लगाने होते हैं, राइट? जिसका ऑडिट होता है एट द एंड ऑफ एवरी फाइनेंशियल ईयर. प्रोवाइड फॉर इलेक्शन ऑफ इट्स मेंबर्स। कुछ मेंबर्स हैं इसमें 15 to 25 की जो रेंज थी, हाउ दे विल बी इलेक्टेड, व्हाट विल बी द प्रोसीजर, राइट, हु ऑल आर द एलिजिबल पर्सन्स, ये सारा कुछ इट कैन टेल, इट कैन मेक रूल्स फॉर द सेम। विजिट एंड इंस्पेक्ट यूनिवर्सिटीज़, एज आई टोल्ड you that minimum standards are to be maintained, right? So whether the university is maintaining that standard or not, or how it is functioning, how it is providing the legal education, or how the students are working over there, do they have the proper prescribed syllabus or not, right? What is the prevalent condition? सो जो भी बेसिक चीज़ें हैं वो इंस्पेक्ट करने के लिए जा सकते हैं। दे कैन ऑल्सो विजिट यूनिवर्सिटीज़ फॉर द प्रमोशन ऑफ द लॉ एज अ स्ट्रीम और एज अ कोर्स, सो दैट मोर पीपल come into this venture. To perform all other functions conferred on it by or under this act, to do all other things necessary for discharging the aforesaid, means whatever the above functions we did, उसको प्रमोट करने के लिए या इसको डिस्चार्ज करने के लिए जो और चीज़ें ज़रूरी हैं वो सारा कुछ भी ये कर सकता है। State Bar Council may constitute one or more funds for the purpose of giving financial assistance to organize welfare schemes for indigent, disabled or other advocates. सो इंडिजेंट मीन्स आर नॉट एबल टू अफोर्ड इट, उनके लिए अगर वेलफेयर स्कीम कोई बनानी है, अब वेलफेयर कैसे होगा, ही इज़ नॉट एबल टू अफोर्ड इट, तो फाइनेंसेस कम होंगे। तो इफ़ आई एम प्रोवाइडिंग यू, और इफ़ आई एम लाइक आई सेड कि कोई पुअर है जो कि अकोमोडेशन, ट्रैवल एक्सपेंसेस, कोर्ट फीस और लॉयर फीस ये सब नहीं कर पा रहा, तो उसको फ्री लीगल एड मैं प्रोवाइड कर रही हूँ। It is free for that particular person, but it is not free for the other person who is doing it on his behalf, right? If the government is providing such facility to that poor person, तो government तो उस lawyer को documentation fees, court fees वो सारा पे करेगी, वो सिर्फ उस concerned person के लिए free हो जाएगा, right? He is not to pay anything, but जो financial assistance of the government या of the council उस चीज़ में लग रही है, उसके लिए पैसा चाहिए ना, so that allocation of the fund or that investment of the fund has to be seen. Legal aid or advice in accordance with rules establishing law libraries means, of course, a book, a place where lots of books of different topics of legal may be there. A state bar council may receive grants, donations, gifts, benefications for all or any of purposes specified above, which shall be credited to the appropriate fund constituted under that subsection. So any grant, donation can be received by the bar council, which has to be जो भी डोनेशन आ रहा है वो अपनी जेब में ना रखते हुए उस फंड में उनको इंक्लूड करना है। क्रेडिटेड मीन्स उस फंड में डालना है ताकि उस फंड की वैल्यू बढ़ेगी, एंड फ्रॉम दैट दे हैव टू इन्वेस्ट इन द schemes. BCI we will do in the next video. Thank you.